Hey, it's Enoch again. I'm here to disturb you with more of commercial transactions. So we're going to continue our discussion on sale of goods from the last module. Please, I hope you watched it, and I hope that you actually gain something from it. So this is we're going to continue from there. It's one big topic, sale of goods, but it has many babies, as we would say. So here in this module, we're going to talk about distinction between sale of goods and other transactions like a contract of service, sale by contract of exchange, and etc. We're going to go on to the formation of the contract of sale and the determination of price. How do we determine price? Introduction to the terms of contracts, generally the general part of it. So let's delve in. The first distinction I would like to draw is between a sale of goods transaction and hire purchase. Hire purchase is something it's not strange to us, something that shouldn't be strange, should be something familiar concept. So the essential nature of a sale of goods contract is that a sale is done by the seller to the buyer, and in that sale there's a transfer of ownership from one person to the other. I'm going to say that again. The essential nature of a sale of goods contract is that there is a transfer of ownership from the seller to the buyer. Remember, in our definition given in section 1 sub 1 of the Sale of Goods Act, that there must be a transfer of property, a transfer of ownership. But in an hire purchase transaction, the hirer only has possession with the option to buy. In an hire purchase transaction, you will see that, the person hires some goods, he has possession of it, he can use it and do whatever he wants with it to a reasonable extent, and then he pays some hires, that's what they call it, that's the technical name for it, or let's just call it rent, in quotes. He pays some rent until maybe he has finished paying all the installments, and then he possesses, and then ownership transfers to him. Or you can decide he doesn't want to buy again and then return the thing back. So that's the basic distinction between a sale of goods contract and that of a hire purchase. That since the hirer in a hire purchase transaction is not legally compelled to buy, he is not considered a buyer. The hirer in a hire purchase agreement is not legally compelled to buy, therefore is not considered a buyer under SOGA. Remember our definition, section 1 sub 1, that there must be a transfer of property from the seller to the buyer for a money consideration. So SOGA does not, Sale of Goods Act, that's what I call it. SOGA does not apply to hire purchase transaction. If there's a hire purchase transaction, the application of SOGA is very, very doubtful. So now, that's the first distinction between sale of goods and hire purchase. The next one is the distinction between a sale and an exchange. I mentioned it before. Now, one of the fundamental things in a sale of goods contract is consideration. It's consideration. And in law, we consider consideration to be like the value. What's the value or what's the price you are giving me in exchange for something? In exchange for maybe my services, in exchange for maybe my goods and co. Consideration. In sale of goods, it is important, it is stated that it must be money exchanged for goods. It must be money that must be exchanged for goods. You can't say that, you are exchanging goods for goods and therefore it is a sale of goods. No. SOGA does not consider such transactions to be a sale of goods contract. It has to be money. Money must be involved. Owo must be involved in one way or the other. But there's an exception to that. Law is full of exceptions and exception to those exceptions. So there's an exception to that, where in a situation where it is partly money and partly goods, like I give you some goods, and then because my goods are of a higher value than yours, you decide to make up the gap by paying me the balance. In that kind of situation, even though originally we were exchanging goods, but yet money became involved. So therefore, if there is no money consideration, SOGA does not apply. If there is no money consideration, SOGA does not apply to that situation. Now, the third distinction I'm going to draw out is distinction between a sale and bailment. A sale and bailment. A bailment is usually a transaction where goods are delivered by one party, the bailor, to another, called the bailee. By one party called the bailor to another called the bailee. The bailee is the receiver. Okay. On terms which usually require the latter, the bailee, to hold goods and eventually will deliver them to the bailor. That's what the bailment is. If you give someone, you hand over your property for a period of time, maybe to make some repairs on it or something like that, and then eventually they will have to re-deliver it to you. So, in that kind of scenario, in a bailment, the bailor only passes possession. It does not pass ownership in his goods. When you give someone to repair your property, maybe like a broken TV or something, you do not give ownership to them. You are merely giving them possession to finish their work on it and then return it back to you. But in a contract of sale, the seller passes not only with the possession, but with ownership of the goods. That there's nothing that the goods have to do with him anymore. He has passed both the possession and the ownership. That's more straightforward. And the fourth distinction I'll be making is between a sale and a contract of service. Now, this is a bit more tricky, a sale and a contract of service. But the main object, being able to tell the difference, is to determine whether the agreement is for the provision of goods or the exercise of a skill. That's the question you ask. That wait, is this agreement that we're about to enter for the provision of a skill, or am I buying something from you? Is the fact that I'm getting a good, a property, an ancillary benefit of the contract? But don't worry, I'm going to explain it. In a decided case, Robinson and Graves, the Court of Appeal held that the contract to paint a portrait, was a contract for skill, not sale of goods. It was a contract of service, not sale of goods. In that kind of scenario, they also stated that it would be a different matter entirely if you were to buy an already painted portrait. In that scenario, it's already considered, in quote, finished goods. If it is a finished painting, it will be a contract for the sale of that painting as the substance of the agreement. And the only thing there would just be a need to transfer ownership of the painting, of said painting. There would be no need of him having to paint all over again, thereby providing a service, not a product. So that's the distinction between a sale and a contract of service. Is it a service that is being provided, or am I just simply getting ownership of an already finished good? Now we have drawn some main distinctions between sale of goods and some similar contracts. And now we're going to go to the formation of a contract of sale. How do we start a contract of sale? It is very simple. We do a lot of things that involve sale in our everyday lives, in our everyday activities. We buy, we sell on a daily basis. No matter how minute, no matter how big, we always execute contract of sales, even though we are not aware, we don't really put our mind to it. Now, the sale of goods has no formalities regarding the formation of a contract of sale per se. In Section 3 of the Sale of Goods Act, it stipulates that it may be in writing, it may be in word, it may be an oral contract, it may be partly word and partly oral. It might be that we have a written agreement that I'm going to sell this to you for this price, or that we just make an oral agreement that, bro, I want to buy this watch from you. How much will you give me for it? Like that. It's a contract of sale. It can be formed partly word, partly written. That, we have already discussed some terms orally, therefore let's just put down the basic parts in writing and get it over with. There are really no formalities, just the contract of sale. It can be made in many ways like we do in our everyday lives. Okay, and now the next subtopic I'm going on to is determination of price. Like I mentioned before, money is a very important part of a contract of sale of goods, because what would be the point of selling something if not to gain something? So, determination of price. As said before, consideration must always be money. It must always be money, except in situations where it is partly money and partly something else. In the case of Aldridge and Johnson, in that case, one of the parties wanted to sell bulls, the other party was with barley. So like they basically exchanged bulls for barley. You know what barley is, like wheat, like a crop. So they basically exchanged bulls for barley. And so definitely there was some discrepancy in the value of those two goods. So they decided to make up the difference in cash, in money. And then the court held that yes, that could be considered to be a contract of sale. Like we said in our exception, that it can be partly money and partly something else, as long as money is involved. Now, how do we determine price? Section 8 of the Sale of Goods Act gives 4 ways to determine price. Section 8 of the Sale of Goods Act gives 4 ways to determine price. The first one is by the contract itself. What are the terms in the contract? That yes, we can just expressly agree that this is the amount that is to be paid for this by the contract itself. Straightforward, straight to the point. The second one, it can be determined in a manner agreed by the parties. Price can be determined in a manner agreed by the parties. I know that a lot of Nigerians are very, very whimsical. We can decide that, oh, bro, let's play for it. If I win, the price is going to be so, 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 and so. If you win, the price is going to be so, 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 and so. It goes to in a way determined, it can be determined in a manner agreed by the parties. 3, it can be left to be determined in the course of dealing between the parties. You know, there are some instances and scenarios like this that you say that, oh, just start the work, don't worry, as we continue, we'll get to know the price and co, and then we'll sort it out between ourselves, especially if it's someone you have a previous or you've had prior business interactions with. That can also be an agreeable way of determining price. And 4, there is a proviso there that where it has not been determined by those earlier 3 ways that we mentioned, by the contract itself, in a manner agreed by the parties, or being determined in the course of the contract, where it has not been determined by these 3 earlier ways, then a reasonable price must be paid. A reasonable price must be paid because there must be a consideration. There must be a money consideration. It is also possible, though, I would like us to know this, it's also possible that price hasn't been paid yet, but the parties have agreed that property should pass. Remember, in our definition, in section 1 sub 1, we mentioned that one of the integral parts of the definition is that property must pass. Property must pass. It is not necessary for price to be paid for property to pass. It means that I can buy something on credit, and yet I'm already the owner, I already own it, property has passed to me, but yet the price hasn't been paid yet. That does not undermine the legality of that sale of goods contract. It is legal, it is binding, even though price has not been paid yet. Okay, and now the last subtopic for this module is the terms of contract. We're just going to go about it generally. Terms of contract is a very broad subtopic under sale of goods. And it is very important in the same measure that what are the terms that make up a contract? What are the things, the nitty-gritty, the nuances of the contract? You see, it could be express terms, things that you say out loud and expressly denote it. It could be implied terms that, oh, it's meant to be part of it. It's meant to be a part of the contract. We don't need to start saying it out loud. There's a tendency in sale of goods, many times in sale of goods to concentrate on statutory implied terms found in sections 12 to 15 of the Sale of Goods Act. Remember, we said that the contract for sale of goods is very, very statutory dependent. And the statutory part of it usually tries to place emphasis a lot on implied terms. You know, originally in the formation of contracts, we said that contracts can be formulated in any way as agreed by the parties, anyhow they want. But in a way, in a bid to like protect the parties and in a bid to make sure that the contract of agreement or the contract of sale does what it is meant to do, there are some implied terms that are stated in section 12 to 15 and stuff like that. And they all have different legal consequences. SOGA, the Sale of Goods Act, classifies them into conditions and warranties. Conditions, they have greater weight than warranties. I'm going to explain that. Warranties are basically terms that are collateral to the main aim of the contract. They are collateral to the main aim of the contract, meaning that they are not the sole term of the contract. Warranties don't perform the sole purpose, the sole aim of the contract. They are just ancillary. They are just part of it. They are important, but not as important as conditions. Conditions go to the root of the contract. So, breach of a warranty will only give rise to a claim for damages. That yes, if as a party, the other party has breached a warranty that you were given. I'm not saying warranty in the sense of like when you buy a phone or something and they write warranty for 12 months plus. That's not the warranty I'm talking about here. I'm talking about warranty as a term. Okay. That to give rights, a breach of it will give rights to a claim for damages, but not the right to repudiate the contract. That's what a breach of a condition does. According to Section 62 Sub 1, Section 62 Sub 1 of the Sale of Goods Act 1893, and please, as we're mentioning these sections, please try as much as possible to open your Sale of Goods Act and just look through with us. Because it's when you are able to look into these acts themselves, that's when you discover the nitty-gritty of it. So, warranties, a breach of a warranty can give rise to damages, but you cannot repudiate the contract, seeing as the main purpose has still been accomplished, even though not exactly the way you want it. And next type of terms, conditions. These are not expressly defined in the Act. That's why I started with warranties, because warranties are expressly defined, but conditions are not. But it is important to note that these are what the contract, conditions are what the contract revolves around. That if it is breached, the other party has the right to repudiate the contract as well as claim damages. This is in Section 11, Sub 1, Sub B. Section 11, Sub 1, Sub B of the Sale of Goods Act of 1893. If a condition is breached, the other party can decide to repudiate the contract and still claim damages. To determine which terms are conditions and warranties, it's not just a matter of what you call them in the contract. You know, Nigerians are very, very smart people. They will make a condition, and then when they are writing their terms of contract, they will term it a warranty, or they will make a warranty and term it a condition. Very well, very smart people. But the law is smarter in a way, in the sense that it's not going to determine what is a condition and a warranty by the name given to it alone. It is going to look at the substance. What is the position of the term in the contract? It's going to look at what the term does in the contract, not what it is called. And again, I would like to note this, that where there is a breach of a condition, you know, I said before that the breach of a condition allows you to repudiate the contract and then claim damages. It's not necessary for you to actually repudiate the contract. You could also, as the innocent party, waive the breach. You could say that, okay, the person still did the contract to a satisfiable extent. Therefore, there's no point to start all over again by looking for a new person. Therefore, let me just waive the breach. As an innocent party, you could also treat it as a breach of warranty. That even though it is a condition that has been breached, something that goes to the depth of the contract, I can decide to treat it as a warranty because I don't want to disturb myself. Therefore, I'll just claim damages alone. I'll continue with the present party I'm contracting with, or you can just repudiate the entire contract on its own. So that's our second module. We have tried to look at the distinctions between the sale of goods and other transactions like hire purchase. We said that, yes, hire purchase transaction is only possession mostly that passes, and it's until you pay the rent finish, in quotes, that's when possession, and that's when ownership passes, and the buyer and the other party in a hire purchase transaction is not bound to buy the goods from you. That's why it cannot be really considered a buyer per se. We looked at the difference between sale and exchange, that in a sale of goods transaction, there has to be money involved. It can't just be an exchange of goods to goods, and that's the distinction between a sale and a contract of exchange. We looked at sale and bailment, that bailment, just possession that's usually involved in the passing up and down. But in a sale, ownership and possession, we looked at the sale and contract of service, that the issue here is that, is there a passing of a property, or is there just the provision of a service? Yeah, we've mentioned that. We also mentioned the determination of price, the ways to determine price, and the terms, the general terms of the contract, the conditions, the warranties, And in our next module, we're going to go deeper into those terms of the contract, especially the implied terms, like I said before. The statutory part of the commercial transaction, the statutory part of the sale of goods, governed by the Sale of Goods Act of 1893, which is what we're using in Nigeria now, deals more in its express terms with the implied terms. Deals more expressly with implied terms, as seen in section 12 to section 15 of the Sale of Goods Act. We're going to look at that in our next module. Thank you for staying with me. I hope that you've actually gotten something new and greater grasp of it. Please like, share, subscribe with your friends, and let's enjoy this journey of sale of goods together. Don't worry, it's not as difficult as it seems. It usually seems difficult, but most of the time when you get to the depth of it, you realize that, well, this is what I was afraid of. Don't worry. Learning with Seth, say we got you. We're here for you. Thank you.